Good morning, everybody. It's 10:01. We'll just see. I think the numbers are just coming up now. Just give it a second, and then we will start. There's the weird sort of awkwardness at the start of a webinar. Well, maybe it's just the ones with me presenting, or hosting. But okay, we'll get started. So welcome everybody to the Collective Redress and Climate Risk an Evolving Landscape webinar. I'll say it's in partnership with DAC Beechcroft, but DAC Beechcroft are very much doing the heavy lifting here. So yeah, I'm really here just to introduce. My name's Spencer Owen. I head up the commercial insurance claims relationship management team for Zurich Insurance. And I'm delighted to be joined by Ian Plumley and Toby Valance from DAC Beechcroft, one of our preferred legal panel partners. So just in terms of the agenda for the webinar, so just a bit of housekeeping. Those that have joined, cameras and microphones are currently disabled. You can ask questions. There is a Q&A button at the top, so ask questions as you go. We do have a session about 15 minutes at the end for any questions, and I'm sure there will be many. At the end, we are recording the session, and if there are any questions that don't get asked at the end, or don't get answered at the end rather, we'll share those along with the slide deck and recording with those that attended. And there's an opportunity for feedback also at the end. So just in terms of the rundown, so Ian will be sharing an overview of emerging risks and developments in the legal and regulatory landscape, and also giving a specific focus on the EU Collective Redress Directive. And then he'll be handing over to Toby, who will take us through ESG and climate change litigation around the globe, again, but with a deeper dive into US and Europe. And then that will be followed by a, as I say, a Q&A around 11:15. So yeah, we look forward to lots of great questions. And I'll hand over to Ian now to start with the overview of emerging risks. Thank you.
Thanks, Spencer. Morning, everybody, and apologies in advance if my my internet cuts out. It's not been doing me any favors since we tried to get online. Been working fine for the last 2 hours that I've been working, but suddenly in the last 15 minutes it's gone haywire. So apologies if I drop out at any point. I'm sure Toby will point out if I've disappeared. What I wanted to try and do was here. So when I was preparing this presentation, I was reflecting, I couldn't remember in my sort of 25 years of working in the market or for the market, time when every sector of the market, where the property casualty specialty was popping at the same time. Now the property sector continues to busy itself with what that really well-known long-tail risk of COVID BI, while focusing also on the sort of day-to-day of nat cat events. Specialty market has plenty of work on its hands as the repercussions of the Russia-Ukraine conflict continue to be felt for years. But it's usually the casualty market that often acts as the barometer for the state of the market. I thought that what we'd like to do is sort of look at where the liability risk landscape is, where it's expanding. And to do that, I thought I'd look at three particular topics. I'd sort of look at give you an overview of the active sectors and some of the emerging risks. If we've got time, and we are limited on time, so if I get through what I wanted to talk about, I'll talk about some of the regulatory involvements, build developments, and how that can shape risk, and that'll be interspersed anyway with some of the emerging risk. And then finally, just talk about collective redress in the EU and the UK. So first off, I wanted to sort of talk about some of the active sectors that we've been seeing, particularly where they are experiencing high levels of product recall action, litigation, particularly in the UK, but also elsewhere. The US obviously being, again, a sort of a useful temperature check for the market. Now, pharma, medical devices, chemicals have been very much the gift that keeps giving to the market over the last 20, 25 years of my career, certainly, and certainly before that. And more recently, we've seen the pelvic mesh litigation, which was resolved worldwide against J&J, Johnson & Johnson, and other manufacturers for injuries suffered as a result of pelvic mesh implant surgery, which was used to treat organ prolapse. And that has included settlements in Australia, a $300 million Australian dollar settlement in 2 class actions against J&J, which was actually the largest liability class action settlement in Australian history. But also in the US, a similar scale, well, slightly bigger, obviously, a $302 million US dollar settlement in San Diego against J&J and Ethicon. And that keeps rolling forward in other states, so those settlements will continue. Similarly, in the UK, we've had the metal hip replacement actions, and that group action has been responsible for the evolution of how the UK courts, English and Welsh courts, assess defects, so that we're moving much closer to a US-style risk-benefit analysis. Probably the most active, and interestingly, from both a sort of litigation and a regulatory standpoint, is the glyphosate, particularly focused on the Bayer Monsanto product Roundup. We've seen class actions in the US and Australia against Bayer, alleging that the use of Roundup has caused cancer. And that litigation is now moving to Europe and targeting other glyphosate products, though there have been no successful lawsuits to date in England and Wales. But it's a particularly active area for the regulators because of its use in public places and by private individuals. It's been increasingly restricted. Now, in November 2022, and despite considerable opposition and a minority of states blocking the proposal, the European Commission decided to adopt a regulation that would extend the approval period for glyphosate until this December. And that particularly resulted from a pushback by the likes of Brazil, who heavily relied on glyphosate for soybean export and where there was no satisfactory alternative. Now, member states will have another chance to vote on the future of glyphosate based on the conclusions of assessments by the EU's chemical agency, the ECHA, and the Food Safety Authority, the EFSA. And the EFSA published a summary of its forthcoming conclusions that the use of glyphosate in agricultural use, strangely, does not pose critical areas of concern for human, animal, or environmental health. And in response, the European Commission has proposed to renew the approval of glyphosate for a period of 10 years, albeit with a number of restrictions. Now, voting will take place this month on whether those proposals should go forwards in the Standing Committee on Plants, Animals, Food and Feed. So we'll have to watch the space to see what happens there. Similarly, automotive has continued to create issues for the market. EU automotive recalls rose 31.7% last year, which had risen from 18% from the prior year. And that may be a result of a number of sort of combined factors: the resumption of pre-pandemic levels of operations, vehicles on the road. But recalls were primarily due to the risk of injury or of fire, although recalls due to environmental risk are increasing exponentially. Also seeing claims arising from counterfeit, substandard, or unknowingly substituted materials. Obviously also had the Dieselgate scandal, which has been rumbling on in the background. And last May, VW paid nearly £200 million to settle 91,000 claims in the UK. A series of other car makers have been facing similar action. Building materials, again, so the cladding group actions have obviously been a major focus off the back of the Grenfell fire, particularly focused on in the UK and Australia. And the focus has been moving from personal injury and property damage to claims for the removal of defective cladding before an incident occurs. it's not covered under standard liability policies, but dismantling and reinstallation and extensions may well respond. More recently, we've had the concrete issue, the RAAC issue, and I'll come back to that shortly as more of an emerging risk. Consumer goods continue to cause huge problems for the market. Last year saw the highest product recall numbers ever. They were up 4.3% on the prior year. And similarly, it was a record-breaking year for the number of units recalled in the US, breaching the 1.5 million units recalled barrier for the first time. Now, with regulatory scrutiny set to increase, I think 2023 will shape up to be certainly similar increases. And those recalls have been driven by lithium-ion batteries, and electrical appliances, clothing, toys and childcare equipment, cosmetics, automotive. Is again in the consumer space has continued to create problems. 1.25 million vehicles alone were recalled in the US last year, so continues to be a real problem. Food and drink, though, is the real driver of the numbers. Food and drink recalls were up 700% in the US last year, and that has risen from a whole variety of issues: contamination, whether that's listeria in frozen fruit, salmonella in chocolate, cleaning fluid in Capri Sun, plastic wood chips in chocolate chip cookie, taking the extent of chips in chocolate chip a little bit too far. Allergens have been creating a huge problem. It's still a very active area following high-profile cases against the likes of Pret a Manger. But it should become a diminishing risk, hopefully, with the UK Food Information Amendment Act. UK Food Information Amendment, which is otherwise known as Natasha's Law, which requires businesses from October 21 to label all food that is pre-packed for direct sale with a full list of ingredients, including specifically 14 major allergens. Flavourings and additives continue to cause problems. Diacetyls are the main focus at the moment, particularly butterscotch flavouring, which is used in popcorn, coffee and pastries. Claims across the US from workers in popcorn factories who are suffering irreversible respiratory damage arising from what's known as popcorn lung through inhaling the fumes of diacetyls as the flavouring product is heated. So it's a pretty active sector without then throwing into the mix the emerging risks, and that's what I wanted to sort of turn to focus on next. Hopefully, Hanover Re have given me a nice definition of what they class as emerging risk, which they class as new or future risks whose hazard potential is not yet reliably known and whose implications are difficult to assess. These risks may evolve over time from being weak signals to clear tendencies with a high potential for danger. And that sort of opens the field up to what I can talk about very helpfully. Some of the risks you might look at that I'm about to talk about on that list, as you can see, might actually be classed as emerged, but in terms of their potential impact on the market, I think the impacts are yet to be fully seen, and for that reason I wanted to have a quick look at those now. E-cigarettes, the first that I wanted to really talk about. Classed as safer than tobacco, but the vape liquids still contain nicotine, formaldehyde, and again diacetyls, which again popcorn lung have the same sort of idea, creating problems in this space. Likely move from the EPL to the PL arena as a result of the inhalation of harmful fumes by vape consumers and passive smokers. And interestingly, e-cigarette maker Juul agreed in April to pay $462 million to settle claims by 6 US states, including New York and California, that it unlawfully marketed its addictive products to minors. With that deal, Juul's exposure will have increased to about $1 billion across 45 individual states. And as ever, I can see that sort of transposes to the UK, Europe. We're normally sort of 5 to 10 years behind. I suspect that will come through a little bit quicker. Second item on the list there is the supply chain disruption due to geopolitical events. The Russia-Ukraine crisis is giving rise to multiple supply chain issues and disputes, particularly in the food sector. One of the less foreseen issues which is emerging relates to product labelling or ingredient labelling, more particularly the shortages of key products such as sunflower oil, which is heavily produced in Ukraine, which are leading to undeclared substitutions. Rapeseed oil is a particular substitute for sunflower oil. And while some regulators have relaxed mandatory relabelling requirements, there's a risk we'll see an increase in claims arising from allergic reactions. And vegetable oil for rapeseed oil is probably one of the areas where it falls outside the 14 key allergens. There are also risks around alternative Chinese and Iranian component suppliers to the Russian airlines due to sanctions. So where they've not been able to get access to Boeing or Airbus spare parts, they've been moving the aircraft to China and Iran for repairs for using non-branded parts, which may well affect the airworthiness of the aircraft in due course. Agrochemicals, I've already talked about glyphosate, but there are problems obviously with glyphosate more generally and other agricultural products where they've been stockpiled and not being used, and where they're now sprayed on crops, which renders them unsellable due to being non-compliant with current regulations. So we'll see some movement there, I suspect. COVID vaccine liability. We think that multiple issues will arise relating to COVID mismanagement by government bodies, but also likely to be product liability claims relating to ventilators, protective equipment, and of course vaccines. There's increasing statistical evidence suggesting an association between certain vaccines and an increased incidence of blood clots and heart attacks. One example of that in August 2023, AstraZeneca was facing dozens of lawsuits relating to deaths and catastrophic injuries that then in turn resulted from vaccine-induced thrombotic thrombocytopenia, which included one from the husband of a woman who died after receiving the AstraZeneca vaccine. So that will be progressing forward. And similarly, BioNTech is facing a barrage of compensation claims in Germany, brought by two law firms that allege that clients suffered long-lasting health damage from their coronavirus vaccine. So I think we'll see more and more of that going forward. Electric and autonomous vehicles. We'll see more and more, I think, as demand skyrockets, as government and customers, consumers grapple with environmental, social and governance considerations and the looming ban on the sale of new petrol and diesel cars in the UK. The regulation of that is obviously a very complex area. The projected growth in EU-based production of electric vehicles, their component parts and infrastructure will increase liability and recall exposures for insurers of what is an expanding industry. One of the more interesting areas that we've seen a little bit of movement is in relation to web content moderators. We saw a flurry of claims a few years ago where content moderators employed by or contracted to certain well-known social media platforms brought claims in the US, certain favourable states like Florida and California, and in Ireland for PTSD, allegedly brought on by viewing graphic, violent and sexual content, and the related failures by the social media platforms to provide adequate training, support and counselling. And the claims were relatively small in scale and quantum, but if they haven't returned or spread to other platforms, I think they probably will do. It seemed like a bit of a dip in the toe in the water by the claimant firms, and I think they'll come back for more, particularly as the moderators are the sort of first line of defence against some of this content, and some of the images obviously they're seeing are horrific. The next area I think we sort of anticipate seeing more is more sporting bodies in relation to the head injury claims. It's obviously the rugby union, rugby league and the football league claims are ongoing. They're being pursued against the world and national governing bodies, resulting from alleged early onset dementia and CTE sustained by former and current professional rugby players. But I think they're the tip of the iceberg. Part of the problem, I think, is that the firm who are running some of the bigger named claimant law firms just have not got involved so far, and I can't believe that they are sitting quietly in the background. So I think we'll see more coming through in the traditional spaces. But I think that the bigger problem is the big cohort of amateurs in each of those spaces. The amateur cohort in the rugby union litigation at the moment, I think, is 33 strong. It's not very big at the moment. I can see claims will come there, particularly where they're less heavily regulated, where there's less medical support, less education around the impact of concussion, but also the wider selection of sports. You look at equestrianism, which I think has the highest incidence of concussion in any sport. Look at cricket, some of the measures that the cricket authorities have brought in around protective gear. But as I say, the bigger risk probably surrounds the bigger and, dare I say, more sophisticated claimant firms who've not yet involved themselves. I think it can only be a matter of time. Follow-on civil claims from Grenfell will inevitably drive claims activity and litigation activity. So the inquiry has recently closed, or relatively recently closed, and I can see that the sort of throughput of civil claims against the contractors, perhaps under the local government authorities, will follow in due course. RAAC, reinforced autoclaves aerated concrete, cannot have escaped anybody's attention in the last few weeks, particularly in the many thousands of anxious parents awaiting confirmation as to whether their children's schools fall within the 150 or so school buildings deemed at risk of collapse due to the presence of RAAC. Don't need to describe what it is, but you can see that the same sort of impacts as have been coming off the back of Grenfell will follow through. The one area and the final emerging liability risk I really wanted to talk about was PFAS, which some of you will be undoubtedly familiar with. Group of highly fluorinated carbon chain molecules. They're man-made hazardous compounds, which include perfluoroalkyl and polyfluoroalkyl substances. There are over 4,700 of them in use historically, and they're ubiquitous and persistent. They're ubiquitous because they're widely used in society and found in many products, including plastic food containers, cosmetics, sunscreens, medical implants, firefighting foam, non-stick cookware, stain-resistant sprays, ski wax. The list goes on and on. The carbon-fluorine bond is the strongest and shortest bond in nature, so it's very difficult to break down, very persistent in environmental media, and will accumulate over time in the environment, hence the term forever chemicals. Now, they can be released into the environment at any time during their life cycle. The manufacture of the substance, the use of the product, linked with all sorts of disease and cancer, particularly thyroid disease, diabetes, infertility, and kidney cancers, and have been tipped to be the next asbestos. And I think that captioning is probably wrong, because I think it's much more persistent than that. The exposure is much more widespread because it's in our water sources. Now, they've been around since the 1930s, most prominently in AFFF, which is aqueous film forming foam, which is used in firefighting. Scotch Guard, Scotch Ban are all big name products that contain PFAS, and the risk is not new. The litigation relating to PFAS has been underway for over 2 decades, and that arises from, again, the ubiquity and persistence of PFAS and the growing amount of scientific evidence pointing towards PFAS exposure-based health impacts. That in turn has driven increasing insurance claims activity where decades worth of coverage is potentially exposed. Now, the initial litigation focused on sort of property owners and residents near plants, manufacturers where it leached into waterways, poisoned local aquifers, and then was sort of cattle and human beings. It then moved over into the sort of the products type exposure, particularly focusing on AFFF, Scotch Guard and Scotch Ban. And then from as early as the beginning of the 2000s, those manufacturers have been subject to individual and putative class action complaints in various state and federal courts around the US. The primary focus at the moment is in relation to AFFF, which is aqueous film forming foam. It's a foam that is used to subdue hydrocarbon fires, so particularly aviation fuel fires, and particularly on military bases where they have to constantly practice, and it's then leached December 2018 into a multi-district litigation in South Carolina. And there are over 3,000 consolidated cases in that NDL as of the end of July 22, which is the last figures I've seen. There are cases joining all the time, 600 of them being added in 2021. First bellwether trial was scheduled for June this year, but earlier this year, settlement negotiations started in earnest, particularly in relation to water provider cases, and the trial was delayed pending the finalisation of a reported $10 billion financial settlement by the largest of the manufacturing defendants. Now, those, I can't speak too much in detail about them, but those settlements are being approved at the moment and will undoubtedly resolve the sort of water provider cases, but that will leave then the individual claimant cases, particularly by firefighters, to be resolved. Now, the US is particularly focused on regulation in this space and moving much forward. The EPA in particular has commenced a 3-year round of regulation for PFAS at a federal level. That started in 2021, so they're partway through that process. We're seeing new regulations coming in more and more at a federal level, but also states are filling the gaps where there isn't regulation at the moment. Just quickly talking about international matters, interestingly, the first notification of PFAS-related claims to the sort of integrated occurrence tower of 3M, who are one of the manufacturers implicated, related to PFAS or AFFF contamination by the fire brigade at Jersey Airport in the Channel Islands. And since then, it's been relatively quiet. But there's been increased activity on the continent, particularly in Belgium. And the one recent exception has been the Flemish government and 3M Belgium reached a settlement of 571 million euros in July last year to benefit the people of Flanders, who had suffered from the output from that plant, and to allow for remediation and deal with sort of some of the potential injury claims. There are follow-on actions in Belgium. There were 9 as at September last year, so a year ago, so I'm sure that number's increased, particularly related to damage to soil and wastewater or rainwater. And there are a series of tort liability claims and environmental injunctions alongside that. Due to the concerns over the impact of PFAS on public health, efforts are underway in the EU member states to regulate PFAS, and certain long-chain PFAS substances have been banned since February this year. But the European Commission has committed to phasing out all PFAS unless proven essential to society and irreplaceable. I think what we'll see off the back of what's been happening in the States and more recently in the US, in Europe, is that PFAS manufacturers will continue to be sued. They'll continue to join to new actions. Plaintiffs will continue to pursue new companies and products in new industries using existing and adapted legal theories. Cosmetics industry has been a major focus. There have been claims against Shiseido, Girl, Coty, L'Oreal, Burt's Bees, relating to false advertising about their products being clean. McDonald's, Wendy's, Burger King have announced plans for use of PFAS in their packaging. There have been class actions in Illinois and California related to the same. And then more chillingly, sort of kids' school clothing has been a major focus because a lot of the waterproof coats, for example, have been shown to contain PFAS. Tail end of last year, there was a report, or sort of middle of last year, sorry, there was a report by the National Academy of Sciences, Engineering, Medicine, which gave guidance on PFAS exposure testing and clinical follow-up, which narrowed the number of conditions that could be shown to have a sort of high strength of evidence link with PFAS exposure. So that will change the dynamic. Some of the conditions that have been complained about will drop away, whereas the focus will switch much more to the kidney cancers, etc., that have been have shown a high level of correlation. The Biden administration will continue to move forward with its regulatory interventions, and that, I think that will again have a knock-on effect. So PFAS will continue to develop. It is an emerged risk, but it is very definitely an emerging risk as well in terms of the exposure that it's creating, and particularly internationally. I'm going to skip over the regulatory developments. I've talked about it a little bit as we've gone along. I wanted to talk about, for the last sort of five or so minutes, collective redress. As ever, I've run out of time, so much to talk about, unfortunately. But the UK and England, Wales in particular, has an established but perhaps underutilised regime for collective redress, and it's seen in four main areas: personal injury and mass tort, data misuse, environmental nuisance, and defective products. Now, there are a number of routes through which multi-party action can be pursued, and the four are representative claims, where one or more claimants represent other claimants with the same interest. Second, not more broadly available, but competition appeal tribunal collective proceedings, which are proceedings dealing with alleged breaches of competition law by a representative defendant. And then multiple joint claims, where multiple claimants use a single claim form, as their action can be conveniently disposed of in the same proceedings. Final and most popular, the group litigation order, which consolidates multiple claims having common or related issues of fact or law into a single set of proceedings in a single court before a single judge. Now, the GLO facilitates access to justice for claimants through cost savings and efficiencies, and avoids different courts reaching different findings on similar facts. It also provides by disposing of all claims in one go. Now, as I say, that's been the most consistently used. There have only been 112 group litigation orders made since 2000, so around about 5 a year. So it's not the hotbed of class actions that perhaps the US is, and I don't think we'll see the claimant lawyers in the UK flying around in private jets anytime soon. A really good example of the ideal claim for this is the rugby head injuries litigation, where the claimants have indicated an intention to seek a GLO, albeit in a slightly haphazard, unstructured manner, which has been the calling card of the claimants' legal representatives in that case. Now, given the UK's established system for collective redress, it's become a popular location for litigation funders looking for claims to support. Funders are attracted by the lack of regulation, by contrast with current EU proposals, as funders are subject to an industry-led voluntary code of conduct. And secondly, the absence of any general requirements for litigants to disclose their funding agreements to either the court or their opponents, which is, again, in contrast with the approach adopted in the US. Now, the UK litigation funding market has grown from a standing start to about 6 years ago to be in excess of £2 billion, particularly with a focus on consumer-led actions and the prospect of an increase in securities litigation. The first of which is sort of strict case and cost management, but the opt-in process has acted as a significant handbrake. Claimants have to opt into a group register before a cut-off date, which is set by the courts, and their interests must be similar, although not necessarily the same. Sample or test cases are agreed by the parties, on which a judge and then all claimants on the group register are then bound by those rulings. However, we're seeing a shift towards an opt-out approach, which is more common in the US, where damages actions are brought on behalf of a class of people without their mandate or even awareness. Currently happening particularly in the case or the context of data loss or misuse cases, with a concern that consumer claims more generally will start to be brought on an opt-out basis. It's worth noting, though, that the courts have so far resisted a move away from the assessment of individual damages or individual compensation towards aggregated damages. So it's very much focused on the individual still. Another trend we're beginning to see in the context of group litigation are claims being brought in favourable jurisdictions on the basis of the domicile of parent companies. And I think Toby will probably talk about that much more in the climate change context. So routes to collective redress in England and Wales are well established. And despite occasionally unenlightened application, claim numbers are increasing, particularly as societal influences drive claims against corporations perceived to be involved in wrongdoing or acting improperly. So I wanted then quickly to talk about collective redress in the EU. And by contrast with England and Wales, Europe is at something of an inflection point when it comes to collective redress. Directive 1828 of 2020 on representative actions for the protection of the collective interests of consumers has been introduced, and it provides for representative bodies bringing collective actions against a business for breach of EU laws, which is then intended to protect consumers. That was required to be implemented by EU member states by the 25th of December last year, was then had to come into force by the 25th of June this year. Provides for wider duties of disclosure, more akin to the sort of US or UK disclosure regimes, and requires manufacturers to disclose all non-privileged relevant documents, whether they're helpful or harmful to a case. The new directive does not affect the UK for fairly obvious reasons. We opted out of Europe, obviously, so therefore the directive doesn't apply to us. But so we have an established regime anyway, so we won't be there won't be any copycatting. The question that sort of arises after the introduction of the new collective redress directive is whether the EU will follow in the footsteps of the US and the UK. Some European nations were required to amend their domestic law to ensure compliance with the RAD. Many member states have pre-existing processes to allow for certain class actions anyway. So taking a number of examples, France, the class action regime has been expanded by recent developments with the creation of a unified regime for class actions before the courts, which encourages access to new groups of claimants, ensuring quicker trials. The RAD was transposed into French law in 2022. In Italy, the representative action legislative decree transposing the RAD has come into force. Class actions were only introduced in Italy in 2019, and indications from our Italian colleagues are that the new representative action might actually end up being used more than class actions and therefore lead to an increased litigation accordingly. Ireland, the RAD was transposed into domestic law by the Representative Actions for the Protection of the Collective Interests of Consumers Bill Act. We don't think there'll be a huge change there. In the Netherlands, I think Toby will come back to talk about the Netherlands. There's a long-standing history and finally, Germany forms of collective redress procedures such as the declaratory model action and model class action, so case litigation, existed prior to the transposition of the RAD. Those procedures are not class actions, as I understood in the US, etc. But the German implementation, the RAD, will allow for collective actions to be commenced, and they expect 15 remedial class actions to be brought against companies each year, while 22,500 individual lawsuits will be eliminated. So it will have a rebalancing effect. Anyway, as of yet, and in conclusion, I don't think it can be said that the introduction of the directive or other collective redress measures has generated increased claims activity yet. It may well still occur, but while continental Europe is unlikely to see the same type of litigious landscape seen in the US, there may be an increase in representative claim numbers in the coming years. So that's all I was trying to say. There's a lot to pack in. Hope I managed to do it in my allotted time. I saw Spence suddenly appear, so my clock has obviously run. So if you have any questions, feel free to stick them through. We'll try and answer them. If I can't answer them on the call, we'll come back to you. But thank you.
Brilliant. Thank you very much, Ian. And the technology held up as well, so that's great. Thank you. And yeah, I was just coming on not to cut you short at all, but just as a reminder that and you very kindly did that already, Ian. But if you do have any questions, feel free to pop them in the chat. But that's brilliant. Thank you very much, Ian. Excellent.
Okay. Oh, have I stopped sharing my slides now?
No,
can you still see them?
We can still see them. Thanks, Toby.
Okay, sorry, my screen's showing something different. Brilliant. Excellent. Well, hi everyone. So we're switching over, and thanks, Ian, for that session, because I think the consequences of collective redress in the potential class actions across the UK and EU play straight into the potential increase in climate change litigation. And that's quite a good place for us to start. I've got up on the slide there what I want to cover today, but if you think about climate change liability exposure, the increase of legal avenues for claimants, be it class actions or a weakening of the corporate veil in relation to parent company liability, it's all part of a sudden increase in climate-related claims in the last 5 years or so. It has been a big jump, and we'll come on to look at a graph which reflects that. So today I want to look at ESG risk as separate from climate change litigation, although they obviously overlap. I think it's important to understand what ESG is, what the risks associated with it are, and putting it in the sort of real context. And then we'll move over to climate-related disputes, starting with a sort of general introduction to the different types of climate litigation there are, and how that litigation's evolved in more recent years. And then I'll have a look at what are the trends we're seeing in US litigation, and then come and look at how things are developing on this side of the pond. And then have a look at the end at future trends around climate litigation. And then finally, if we've hopefully got time, we'd like to spend some time looking at what the insurance industry can perhaps do to help support customers in managing ESG and climate risk. And then we'll go into the Q&A section at the end, which might be a helpful point for a discussion on that last topic. The ESG risk, I've got up here on the screen, on the slide, it's a Venn diagram that we put together, which tries to capture the aspects of ESG. And this has recently been updated, so it's not every aspect, but it's what we're seeing as the most pertinent points that are of relevance at the moment. And if you look at ESG risk, some say it's a new risk. I think if you look at some of the aspects on that on the Venn diagram, some are certainly new risks. If you look at greenwashing, activist litigation by climate activists, automated vehicles, COP28, they are issues which have come around more recently. But other elements of risk on that diagram have been around for a long time. Pollution liability has been around for decades, as Ian's just talked about. The energy transition, okay, it's accelerating now, but it's been being looked at by the energy sector for a long time. Supply chains have always been an ongoing issue. Perhaps pertinently, legislation and regulation around corporate social responsibility and climate change are nothing new. And actually, the term ESG was first coined back in 2004 by a group of lawyers. It's just that it's garnered more attention since the Paris Agreement. So I think there's just been a shift in how you view, or how people view ESG. And so I think a comment to make about ESG is that it's taken on many forms more recently. not least generating a whole industry of its own of consultants, advisors, and investments. And it's probably moved away from what it's actually at its core, which is businesses acting in a socially and environmentally responsible way, achieved through effective governance. That's simply what it is. And it's no accident that ESG was first coined when the UK Companies Act was being looked at, and which introduced a whole section of CSR. So 2005, 2006, that was when that came in. And then equally, the Climate Change Act is from 2008, which has been legislating about how the UK aims to achieve its net zero targets by 2050 for the last 15 years. Okay, it's gone through a few changes, but it's certainly been there. So I think it's not accurate to treat ESG as a new risk per se. In fact, ESG is too broad a consideration to see as a risk in its own right. I think rather the risks related to ESG are broad. Some have been around for some time and others are new. But what has happened more recently is an increased focus on the various aspects of ESG risks, such as environmental climate change concerns brought around by ever-increasing impacts of climate change across the globe with the increased natural disasters that we see. And then an increased awareness on the social impact of businesses in terms of diversity and inclusion and human rights and modern slavery. So this is what's sort of developed more recently. One new risk that does associate with ESG is sustainability reporting requirements, which is, I would say, is a risk in its own right. And that I want to come on to talk about that next, because I think that's something that's worth touching on, and it does actually play back into some of the climate change litigation we will talk about later, particularly greenwashing. So as a start on that, I've got a slide up, which I've called the acronym minefield. These are just some of the acronyms that are relevant to current ESG sustainability reporting requirements. The sharp-eyed amongst you will see that there are a couple of repetitions there, but on the whole, they all have some part to play, either voluntary or recommended disclosure requirements. And I think the issue is that companies have to grapple with all this, whether compulsory or not. They're having to look from a perspective of what do they have to report on. And the bigger a business, the larger its global footprint, the more reporting requirements will need to be grappled with, as this varies across different jurisdictions. And sometimes there's overlap and commonality, other times not, although there is a drive to try and improve the sort of the synergy between the different reporting requirements. So just briefly, and I won't spend too long on this because I really want to get onto the meat of the climate change bit, but the requirements vary, and I'm just going to look at the UK, the EU and the US briefly, but obviously there are regulations which come elsewhere. I think the kind of key messages from this are that when your companies are looking at the disclosure requirements, they need to look at it from the lens of which jurisdiction are they reporting in. And it can be that having set their sustainability disclosures in one jurisdiction, there's a temptation to use it elsewhere, but it has to be very carefully done and managed to make sure that it fits with the requirements of different jurisdictions. And alongside that, there's a temptation to use the voluntary disclosures that came under the TCFD, the TNFD, which is the new one, Task Force for Nature-Related Financial Disclosures. The TCFD is the Task Force for Climate-Related Financial Disclosures. But because they're quite detailed and thorough, and a lot of the compulsory reporting requirements are based on that, again, there's perhaps a tendency to perhaps use those. But again, it really requires looking at the detail so you don't get caught up. And then wrapped up in all that, if you've got a global operation with all these different sustainability reporting disclosure requirements, how a business communicates what it is doing in that regard has to be managed through their global network. And there has to be careful management in terms of what it says in one jurisdiction doesn't get spread to another. So it's definitely a very complex area. As I say, I'm looking at the UK, EU and US, but just to say there are emerging reporting requirements in numerous other jurisdictions such as China, Hong Kong, Japan, South Africa and New Zealand and others. So looking at the UK, the current focus is limited to climate change disclosures, and I'll put that in context when we talk about the EU. And the three sort of legislative regimes that we have in the UK are all based around the Task Force for Climate-Related Financial Disclosures, so the voluntary ones. So that's where they've emerged from. and they only focus on climate change aspects, nothing wider than that. There's a plan that following the publication of the International Sustainability Standards Board standards, that the UK government is expected to adopt these in due course, but at the moment it's just limited to effectively the TCFD. The EU has gone a lot further, and I think the EU is probably the most evolved. The reporting requirements started out the back of the Non-Financial Reporting Directive in 2014, which require businesses to focus on their management reporting around environmental, social, and employee matters, and respect for human rights, anti-corruption, and bribery matters. So you can see it's really broader than the UK requirements around just focusing on climate change. That was enhanced by the taxonomy regulation in 2020, and then more recently, the Corporate Sustainability Reporting Directive, which is still due to come into force, but that's the one that's really up the ante. And it requires a far broader reporting requirement than the UK regime. The environmental disclosures include climate change, but also require reporting on pollution, water and marine sources, biodiversity and ecosystems, and resources and the circular economy. And then they also require reporting around social disclosures and then governance. So very much more ESG broader. There's also a requirement for double materiality. So corporates need to disclose both the material effects of sustainability matters on them and their impacts on people and the environment. So looking at both those aspects. And then finally, the reporting has to fit around their business model and strategy, showing that it's compatible with the aim to limit global warming to 1.5 degrees in line with the Paris Agreement. Then looking to the US, it's not as advanced as the UK or the EU, and it takes a different viewpoint, and that sort of reflects the different political landscape in the US. The SEC is developing disclosure requirements at the moment, and there's a draft set of rules which were released in March 2022. They've been delayed. They're expected to be finalised in October, but there's also an expectation that they may be delayed further. They're very climate focused, and then it really relates to the business's actual or likely impact on the impact of climate on the business, and then how the company is managing its governance of climate-related risks. So looking at those two aspects. But if you look at comparison with the EU is trying to define what constitutes green and sustainable and is encouraging disclosures on that basis. It's very much looking at, moving to be more sustainable. The SEC's approach, on the other hand, is not to try and define what ESG and sustainable mean, but simply to ensure that investors are getting the information that they need to help them make decisions on their investments. So it's very one-sided. Just briefly on enforcement, it's been limited to date and not due to failures to meet required reporting obligations, although that is expected to come. It's more been in line with breaches of things like international accounting standards, where climate change risks have not been properly considered in financial statements, or misrepresenting green credentials of investments as a greenwashing. That's more the focus. But as the disclosure obligations evolve, expect to see more enforcement and more disputes in that regard. And then finally, potential for harmonisation of reporting requirements. Sadly, not looking terribly hopeful. There is the aim with the ISSB that the UK might adopt for that to be a broader reporting requirement, but it comes up against the EU, which is far more evolved, and there isn't a joint initiative to try and coordinate, but equally they're looking at things from slightly different perspectives. So it is an ongoing issue. So climate change litigation, it has exploded, as you can see from this graph. Over 2,340 climate-related cases to date, and you can see the sharp increase which followed the Paris Agreement. There have been 190 cases in the last 12 months. 2021 was the peak, as you can see, and what's really interesting about that year is the sudden uptick in claims outside of the US. which effectively accounted for almost half of them, whereas the US had generally led the way, whereas the rest of the world took notice and caught up. In terms of geographical spread of these claims, the US has always led the way, and it's not going to change anytime soon. 1,590 of the 2,340 cases emanate from the states. And interestingly, Australia is next on the list. And it's what's quite interesting when we look at the jurisdictions where there have been more claims, trying to make sense of it. The US, I suspect, because it's more litigious. With Australia, I think it has more to do with the fact that it has faced a significant range of the impacts of climate change, facing devastating wildfires and significant flooding on more or less an annual basis. Next on the list is the UK, then the European Court of Justice, followed by Germany in terms of numbers of cases, and then Brazil and Canada. We'll come back to look at Germany because that's an interesting case study in itself. The remaining 317 cases are spread across other jurisdictions around the globe. What makes for a compelling trend is the emergence of climate change litigation in new countries each year. And the bottom of the slide shows new jurisdictions from the last 12 months. So Bulgaria, China, Finland, Romania, Russia, Thailand, and Turkey. Currently, there are much less claims in countries in the global south, but that is expected to change as well, as that region is often experiencing some of the most extreme weather effects and difficulties caused by climate change. And there's also an expectation of state versus state climate litigation that will come in the following years. Then just looking at the different types and objectives of climate change litigation, to give this context, can't group them all, but and there's a wide spread across the 2,340 cases that we've seen to date. But outside the activist litigation against states, which we will talk about in a second, and they're referred to as government framework cases. If we look at the climate actions involving corporates, they roughly fall into one of three categories. There's the alleged contribution to climate change through greenhouse gas emissions, which is you are being sued because you are a big emitter, and the claim is either intending to alter corporate behavior or seek damages for harm caused by climate change, or both. Adaptation claims. Now, this is a really interesting aspect, and we'll come to look at it a bit more on the next slide, but this is where a cause of action arises not from the defendant's contribution to greenhouse gas and therefore climate change. Rather, it's the defendant's failure to adapt to the consequences of climate change, either as part of the transition or increase in physical risk. And I think this is a really important type of climate change litigation, and that's where we'll look at it a bit more. The third category is related to breaches of laws, regulations, and duties related to climate change. For example, greenwashing, where there's statements about the business's impact on the climate, securities actions, where corporates are alleged to have failed to disclose material climate-related risks. And these are on the increase because of increased claims brought against governments, and then governments thereby bringing in new laws and regulations around climate change. And then, so what are the objectives of the climate change litigation? Again, it's quite broadly spread, but a big focus for the climate activist claims, where they're brought against governments or corporates, is change in behaviour. So they're not seeking damages or any kind of compensation. It's simply saying, you as a big emitter, we want you to change the way you operate your business or the way you're financed, etc. Secondly, looking for redress following environmental disasters. That fits with the adaptation litigation. So where a harm has been suffered because of the impact of climate change, looking for damages and reparations in relation to that. And then finally, remedy for damages for harms caused by climate litigation. So we'll look at a few cases on that in the next few slides. So just a bit more detail on adaptation litigation. The more recent expansion of climate-related claims since the Paris Agreement have followed a similar pattern, particularly in Europe. Oh, sorry, I missed a slide. Hang on, where's it gone? This one, sorry. I'll come back to adaptation litigation. This is a template we're seeing in terms of the evolution of different types of climate change litigation and how it leads from one from governments to corporates. This is more prevalent in Europe, but it does happen in the US. And so first you get this activist litigation by NGOs against national governments, where they're arguing that the climate change policies of that country are not fit for purpose and require significant amendment. And then following changes to national law around climate change, the activists then turn on the major greenhouse gas emitters to attack their climate change transition strategies. So not asking for damages, but just forcing them to change how they approach. And they aim for forcing a change in corporate behavior. Good example of that was in the Netherlands in 2019. The Agenda Foundation, acting on behalf of 900 Dutch citizens, brought a claim against the Dutch government for its failure to do enough to protect its citizens. The claim was successful, and it forced the Dutch government to introduce a whole raft of new environmental initiatives. Following the Agenda ruling in 2021, Friends of the Earth Netherlands brought a claim against Royal Dutch Shell. And this was the first climate activist claim against a corporate entity, and relied upon the new legislation and a mixture of human rights and the Dutch tortious principle of the unwritten standard of care, which is very broad. The claim was successful, and it marked the first time that a national court has ordered a private company to reduce its emissions in line with the Paris Agreement. Interestingly, in that claim, the court took a really negative view of Shell's corporate strategy relating to its proposed energy transition, describing it as intangible, undefined, and non-binding for the long term, i.e. leading up to 2050, and as such was incompatible with Shell's reduction obligations. I think that's really interesting, because we'll come on to look at another claim against Shell in the English courts, where the court took a very different view of Shell's strategy and query whether they've put more effort into it since the Dutch case. So as more activist claims against oil and gas companies seeking change develop and succeed, you get a shift then to claims seeking damages against those corporates. And around 60 cases have been filed against the so-called carbon majors, with 20 of the 29 US cases filed by cities and states. We'll have a look at those, but they are where there's a shift and then a claim for damages rather than a change in behavior. And then finally, there's a move beyond the major greenhouse gas emitters to other greenhouse gas emitters. So a good example is a claim against Holcim, it's the Swiss cement manufacturer. They're being sued by the islanders of Pari in Indonesia, where the claimants are seeking both a reduction in greenhouse gases, so a change in corporate behavior, but also financial compensation of the effects of climate change on their community. So that's the template that we see, and that's what's driving things. And we'll come back and reference Germany. So sorry, just adaptation litigation. I think it's a pertinent one, because if you look at your customer base and you can identify the big carbon emitters, the oil and gas companies, you can see where their vulnerability might be. But adaptation litigation is much broader than that, because you're looking at companies where they've failed to take account of the consequences or the change caused by climate change, and that's really quite broad. And needs a bit more focus and consideration. So you get claims with businesses against businesses where there are third-party losses arising from climate-driven disasters that could have been mitigated. Now, the Arkema cases followed Hurricane Harvey. It was a chemical plant in Texas where it was known that there were flood risks. It came out in the insurance engineering reports when they were looking at potential exposures. The issue was, though, when the site was originally built back in the 1950s, there was no flood risk. But because of changes in climate, there was now a flood risk. The area was exposed to flood risk. And so the arguments put forward was that you couldn't rely on force majeure, and that the reality was that this site was exposed and steps should have been taken to protect the site. What happened was the site flooded, it caused a knockout of power, which then led to explosions and fires in parts of the chemical plant. So it's about spotting those unexpected unknowns, and I think that's quite an interesting one for the insurance market to look at, because there will be a lot of data around physical risk exposure. What's your physical risk, your first party risk? Well, that can be transposed into, well, how might that play out on the third party side? So I think it's an important part to be looked at. D&O claims relating to investments in greenhouse gas projects that face financial risk from climate change. I've mentioned Client Earth and Shell, and I will come back to it, but this is about claims against companies who seem to be taking a blind view of the future transition away from reliance on oil and gas and therefore stranded assets. So it's that aspect. There's also professional and product liability risk, where you've got claims against engineers, architects, and manufacturers for failure to factor in the changing climate in design of products. I think if you look at the VW emission scandal, that was a precursor. That's a transition risk, but it plays into, because of a change of environmental policy in the US around emissions, they took steps to try and find ways around it, which caused them that liability. But it's really quite broad in terms of when buildings are designed now, or were designed, should it have factored in how climate change is impacting the environment? And then I've got up there the US baby food arsenic rice scandal. That was a claim where arsenic is prevalent in rice, it's expected, but if it's rice is grown in hot or dry conditions, it will absorb more arsenic, which will be more concentrated in the soil. And in the US, they found high levels of it in the rice that was in baby food, and it left to a series of claims. And then employers' liability. That is not a real case or risk, but I was talking about it with colleagues. With workers working outdoors in more extreme conditions and heat waves and hot weather, is there increased exposure for employers in that regard, and increased skin cancers? So that's what adaptation risk is. Harder to spot, much wider, and therefore something really to focus on. Then just looking at things from what's going on in the US, I think pertinently, big decision back in April of this year, the Supreme Court said, made a ruling that in 5 cases originally filed in state courts against fossil fuel companies for alleged tort damages from the impact of climate change, the defendants urged the Supreme Court to allow the claims to be heard in the federal court, where they argued the federal common law would preempt the state law for claims and end the lawsuits. The Supreme Court disagreed, and the cases have now returned to the state courts. So watching how those play out will be very interesting. And actually, a number of those cases, because it's against the fossil fuel industry, a lot of the claims are presented around deception. And these deception claims, from a legal perspective, I think are fascinating. The argument being these oil and gas companies have known for decades about the consequences of the production of oil and gas, and deliberately deceived the public and withheld this information. That might play through in terms of insurance cover for these type of claims, in terms of fortuity and known risks. So a really interesting dynamic. There are about 5 or 6 of these claims, and they all have been kicked into the long grass in terms of procedurally. They've sort of been pushed back. So it's interesting. It's almost using legal tactics to try and prevent those cases developing. But I think they will get there. We talked about adaptation claims just previously. There are numerous ones in the US. It really is a big focus. A lot of claims have come out of the wildfires, claims against power utility companies saying, due to their failure to maintain their infrastructure in forested areas, knowing that those forests were generally much drier for longer periods, that the failure of that infrastructure with sparking, etc., caused the fires. We had the big freeze in Texas in 2021, and again, the power utility companies are facing claims for their failure to upgrade their network to deal with increased cold snaps in that part of the state. Held Montana, that's a very recent case, came out over the summer. It was brought by 16 youths in Montana against the state government, and it was notable as the first climate action to proceed to trial in the US, considering constitutional rights and the constitutionality of existing state legislation, and allegedly denying those same rights. It's being appealed, but there's a potential that this argument will be applied in other states with similar constitutional rights relating to a right to clean and healthy environment. There are about 3 other states at the moment, but it's just that idea of the consideration by the court, and they looked at the science behind this climate change claim. So it's a real leap forward. Counter to that, the ESG backlash. I'm sure some of you will have heard about that. This goes back to my initial discussion about what ESG risk is. I think it's become a political tool. ESG has been taken up by different sides of the political spectrum. Reality is, businesses know that they have to continue operating. So there's been a change of approach by some businesses operating in the US. For example, McDonald's has removed all references to ESG from any part of its website, but it hasn't changed its ultimate ESG strategy or its corporate social responsible strategy. That still maintains the same because they know as a business they have to do this. But it's been politicized, and so I think there's some suggestion there's maybe sense of moving away from the concept of ESG as a title. There was a big upsurge in cases, climate change litigation cases post-Trump administration. So query what will happen next following next year's election. You know, it does have a big influence in the US as to how disputes play out. And then a key insurance dispute. I think this is a really pertinent one, obviously, for this discussion. Aloha Petroleum and National Union Fire Assurance. This is a claim, a policy dispute for coverage relating to fence costs. It relates to an underlying claim in Hawaii against various oil and gas companies. But Aloha Petroleum's insurers said they would not be providing defence costs because of a pollution exclusion in the policy. And this is something we might see coming up again. And it's a long-running dispute over the meaning of pollution exclusions and liability policies, and this takes it up. Is greenhouse gas an excluded pollutant? I'm not going to discuss that now because we haven't got the time, but we can come on to talk about it afterwards. But it's certainly going to be a pertinent issue about policy coverage, and that's where the last slide is what I'm going to go for. There's also in the US the issue about duty to defend, which causes a different dynamic, but that case is ongoing. Europe, still by far and away the significant majority of the claims are by NGOs, by climate activists against governments and corporates, but that shift is starting to change. I mentioned earlier about the template for litigation: sue government, sue corporates, and Germany is a great example. There was a claim Neubauer against Germany, and that resulted in a big change to the Climate Protection Act in Germany. And off the back of that, there's been a massive increase in claims against corporates. Not many that successful. Some have been against car manufacturers, for example. But the fact is, though, once you get a change in legislation, it allows the activists to start picking it away at corporates. The case up there, Lulia and RWE, that's another German case, actually predates the Neubauer case. It goes back to 2016. You might otherwise know it as the Peruvian farmer claim. I mention this because it's really relevant to the development of attribution science. Attribution science is about how you attribute a greenhouse gas emitter's emissions to the amount of climate change that it causes. And then second to that, how much did that climate change that's been caused by that emitter cause damage to the claimant? It's no easy thing, and that was where most damages claims fell down in the early days of these climate change litigation cases. But the fact is, there has been a huge amount of research in this area, and it's ongoing. A lot of it links to this case, and they're pushing it further. And in that case, they have been able to attribute RWE, the power utility companies, emissions from its coal-fired power stations to the amount of climate change that's impacted in the area where there's farmer. So say they're experts. But the really important part about that case, it's got to the discovery expert stage. So defence costs have really increased there. Client Earth and Shell, that's a really good one. I don't really have time for it, but all I want to say on that is, if you remember earlier, I talked about the claim by the climate activists against Shell in the Dutch courts where they won, and the court were very dismissive of Shell's transition strategy. The opposite happened here. Client Earth brought a claim against Shell in the English courts. It was a derivative action. They're notoriously hard to get off the ground, but the court was very dismissive and provided a very detailed judgment. But one aspect which really stood out for me was they said how good Shell's transition strategy was and how clear it was, and so there was no basis for the claim being brought by the activists. So that's a takeaway point for customers. If they've got a good strategy in place, you can't always prevent the litigation happening, but it's a very good way of limiting your potential exposure to those claims. Sorry for rushing these last bits. here's our climate litigation map. We'll send around a link afterwards. We're tracking 20 of the top key claims that we think are relevant to the sort of the evolution of climate change litigation. Future trends, I think we'll see more claims outside of the US, Europe, and Australia. Biodiversity risk is becoming much more of a factor now, including claims relating to impacts on oceans. In that case up there, Agostino, Portugal versus 32 other states. That's all about rights of children in Europe. If that goes through and successful, expected in the next 18 months, it could be a massive change. And then, as I say, ongoing improvements in attribution science. If that starts to play through and cases are successful, we could see a massive increase in damages claims. I will stop there. I'll leave that up there for discussion. But this is how the insurance market has a role for its customers in terms of managing this climate change litigation. There are existing policies up there. We talk about how they might respond to this litigation, but what's the plan going forward? How will we continue to support large corporates who are exposed to climate change litigation in terms of developing new products or evolving existing products around the potential liability, as well as the first party aspect in terms of reinstatement and repair? How do we manage that where businesses can't simply replace what they had there before? To get permits to rebuild a building, they need to show that they're going to use new environmentally friendly products. So it's, again, how does the policy respond? Spencer, sorry, I've got there with 2 minutes over. So I will hand back to you.
No, and no need for apology at all. That was great, fantastic session. Thank you, Ian, and thank you, Toby. Really much appreciated for taking the time to share some of the insight and some of the trends and developments that you're seeing. So we do have some time for questions. There are just a quick reminder that you can post those in the chat. We do have a couple that have come in. The first, I think, is probably to yourself, Toby. Are any countries seen as easier places to bring climate actions?
That's a good question, because it depends on what kind of action they're looking to bring. The Dutch courts have been seen as an easy target, and that's not just in case of climate change litigation, as Ian mentioned earlier, in terms of parent company liability, and that's why Shell's been picked on. They've also got this broad principle around tortious liability, this unwritten duty of care, which, if it's unwritten, how broad can it be? And certainly the courts have given it a very wide remit. And as things stand, Shell lost that claim. It is being appealed, but if that appeal fails, you can expect other large emitters to be targeted in the Dutch courts. Conversely, if you look at the approach of the English courts, we also faced over here a claim against the government, judicial review, which was only partially successful. And frankly, our government's really done very little about it. They had their transition plan, which was criticised, asked to be revamped, was revamped in March, and actually Sunak tore most of it up a couple of weeks ago when he took all the restrictions out. And then you look how that plays through to the claim against Shell in the English courts, which didn't succeed. So a different approach. So I think the Dutch courts were open to it. The US, well, you'll see more claims there. There does seem to be a shift potentially. I think when you look at the increase in number of incidents of natural disasters and the harm it caused, if you look at the Maui fires, that really shifts the focus, I think. Is there a difference between common law and civil law jurisdictions? Possibly. I think common law jurisdictions have generally come back with the court saying, look, if something needs to be brought in, that's not our job, it's the government's role to bring in legislation. So there is a slight difference.
Okay. Great. Thank you very much. We just had another question come in from Mark Knowles. Are UK councils likely to be targets of litigation for their transition or general climate emergency strategies?
That's a good question. Legislation protects them, and I think whether that changes, this is the, yes, they possibly could be, but in terms of showing how they're failing, it's a difficult one, because as I say, legislation at the moment sort of allows them certain leeway, but again, if they don't make changes, I think it was a discussion I had with a colleague in terms of what about increased flood risk and flooding liability. Basically, they can't be found liable. But I think if they don't show that they're making efforts to adapt, so in terms of as the question comments about transition, then yes, and it could fall in line with the same approach that national governments face, and it's quite common in the States, as it's on a state basis, not just on a national basis, for claims to be brought. So yes, I think there is potential. At the moment, there's a certain protection afforded by legislation, which prevents those claims being brought, but because of the changes brought around by climate change, I think it's harder for the councils to ignore that.
Yeah, I've certainly seen a couple of tries at sort of breaches of the Human Rights Act claims for failing to sort of sustain their emission standards, particularly against London-based councils.
Yeah,
they haven't gone anywhere, but certainly been, again, a sort of dip of the toe in the water, see how far they can get. And I don't know where they've gone. We were asked to look at it from a coverage perspective, but I haven't seen them progressing. But yeah, certainly people are looking at it.
Thank you. Thank you very much. I hope that answers the question, Mark. And we have one final question. Are litigation funders getting involved in climate change litigation?
Not yet, because there are very few damages claims that have been successful, so there's no money in it for them. But if we look at the Peruvian farmer claim, although that claim isn't for actually a large amount of money, but the concept of succeeding in a claim for damages related to attribution science could see a turn. And also, I think there is Aristata Capital. They say they are ready to go in terms of providing funding that's focused on impact, and I think they're looking at it from a perspective of, alongside other aspects, environmental protection, quality, indigenous rights, they're also including climate change in there. I think as soon as you see a successful damages claim, then you might see the funders looking to get involved and start investigating where they can make the most money out of those type of claims, but not at the moment.
Not at the moment. Okay, great, thank you. I'll just check the Q&A, see if there's anything else come in. I don't think there is. No, I think that is all from a questions perspective. Clearly a very thorough and comprehensive presentation, and thank you very much for taking the time to share that insight. Really very much appreciated. I hope everyone enjoyed the webinar. We will share the recording and also the slides, and also probably a short feedback just to get your views on how well received it was. I'm sure it was very well received, and if there's any other topics that you'd like us to cover. But I think all that's left for me to say is just express my gratitude for Ian and Toby and DAC Beechcroft for supporting and leading this webinar, and yeah, wish you all a very enjoyable week. Thank you very much. Thanks all. Cheers.
Thanks all.
Thanks everyone. Take care.